I am sitting here with TD&A's broker and one of the principals, Art Putzel. Art is a licensed broker in 6 jurisdictions: DC, Delaware, Maryland, Pennsylvania, Virginia, and West Virginia, a CPA, and a former Deputy Director for Economic Development in Baltimore County. Art's education includes a BS in Economics and a BS in Urban Studies from MIT and an MS in Urban Planning from Johns Hopkins University. And today, we have the opportunity for Art to speak about mistakes tenants make when signing a lease. Welcome.
Thank you. First of all, I'll say that all those qualifications enabled me to take a lot of continuing education every 2 years. That's one of the privileges of that.
I bet. Thank you. So to start, what is the most common trap you see tenants fall into with leases?
Okay, so let's talk about leases versus sales or purchasing. I always say that the difference between leasing something and buying something is the difference between having breakfast with somebody and marrying them. I mean, you could have breakfast with Genghis Khan and probably have a very interesting breakfast because he was a very interesting guy. You might not want to marry him. If you buy a property, you have a relationship for a couple of months, you buy the property and you're done. If you lease, you could have a relationship for 5 years, 10 years, 20 years, 30 years down the road, and that lease becomes a marriage contract. I think you said, what are the most common pitfalls? Generally, it's not truly understanding what it is you're signing. Examples are, what really are you leasing? If you're leasing a 2,000 square foot, let's say a 2,000 square foot freestanding building, meaning it's not part of a shopping center. Are you leasing the inside of the building? Are you leasing the inside and outside of the building? Are you leasing everything inside the sidewalk? Are you leasing the entire parking lot and the building? Because the definition of premises in the lease defines what your responsibilities are. If you're responsible for all the repairs to the premises, if it's everything inside the walls, it's one thing. If it includes the parking lot and the dumpster and everything else, it's another thing entirely. Another pitfall is in a lease where you are responsible for costs other than the basic rent. What are those costs? How are they defined? How carefully are they defined? How well do you understand what you're paying for?
Gotcha. That's
a start.
So when you see these common pitfalls and you try and advise your clients the best way possible, are they responsive in terms of, accepting your feedback?
Generally, and really it depends. It depends on the client. We represent a fairly significant range of clients. On the sophisticated end, you would probably say that Starbucks, Party City are perfectly capable of reviewing lease terms on their own. They're big boys, they understand. On the other hand, if you, Sophia, were leasing your first store because you've always wanted to sell knickknacks, you're probably not that familiar with reading a 60-page lease and understanding what's in it, and you have to find someone you trust, and hopefully your broker, your agent, is somebody that you trust.
Absolutely. So in talking about these common pitfalls you find, are there any laws or regulations that protect clients per se?
So, of course there are laws, there are things that you could put in a lease that are actually contrary to public policy and therefore not enforceable. But in general, I would say that the difference between commercial real estate leasing and sales and residential sales primarily, there's another thing I say a lot, the risk of offending people. The presumption under the law is that in commercial real estate transactions, the presumption is that Both parties are sophisticated business people represented by competent counsel. The presumption in a residential real estate transaction is that everybody's a neophyte deserving protection from themselves. So, are there laws that protect tenants from the kind of pitfalls we're talking about? No, there aren't. It's a matter of negotiation, and the time to negotiate is before you sign the lease.
Well, this is very interesting and kind of brings me to my next point, because, from my knowledge and just overseeing so much of the work other agents do, I always see and hear the word LOI. But LOI, means letter of intent. That doesn't necessarily protect the client who happens to be the tenant, correct?
Well, the idea of an LOI, it doesn't protect or not protect either party. The idea of an LOI, which is not common in the residential real estate industry, is a letter of intent is something that is negotiated between the principals or between the principals and their agents, which lays out the basic business terms. And depending on the nature of the parties in the transactions, a letter of intent could be 1 page long, or I've seen them that are 10 pages long and in tremendous detail. The letter of intent is just what it sounds like. It's a letter of intent. Usually if there's a paragraph at the end that says, no matter what it says above, this is not binding. The purpose of a letter of intent is to get the parties to agree on the business terms before everybody starts spending money on attorneys to draw up a lease. Because I've said this even before I got into the real estate industry, that if two parties agree on the concept involved, you can generally find the words to put that on paper. If you don't agree on the concepts involved, you can spend 6 iterations trying to come up with the words, and you'll never get there because there's no agreement. So the letter of intent is an attempt to get the basic concepts on paper. So then you hand it to an attorney and say, draw me a lease, and hopefully when somebody reads the lease, they don't go, oh my God, that's not what I intended.
Yeah. Thank you for clarifying. We just talked about, the common pitfalls you tend to find in clients, but what are the top ways tenants can avoid falling into, these lease pitfalls?
Obviously, it's in our enlightened self-interest to say, hire an agent that knows what he's doing to represent you. Some attorneys, some that are familiar with commercial real estate, are very good and can do a lot to protect you, but you really need somebody that knows what they're doing. And some of these things, and I lean on real estate attorneys all the time, but some of these things they don't have experience with. Most of them don't have experience with administering common area maintenance clauses in leases. They've written them, but they've never actually administered them. And I'm sort of a hybrid. I spend part of my time being a broker and part of my time being in our management company administering leases. So I've seen things where the attorneys have negotiated something and then it's left up to the clerks to actually implement it. We spent a lot of money in a development we did where Target had owned a parcel that we had sold them, but there was a reciprocal easement agreement among us. And we spent a lot of attorneys' money negotiating that agreement. And several years later, I was talking to somebody. We were trying to determine whether or not a certain expenditure was permissible under the agreement. And she said to me something equivalent to, we have 775 stores, we don't do it differently for you. And I said to her, well, if somebody had said that during our negotiations, we could have saved a lot of money on attorney's fees.
Wow. I find that there are so many similarities between the common pitfalls you find in tenants and the laws and regulations, because at the end of the day, the common pitfalls you're finding are ultimately, due to the laws and regulation. Is my assumption correct?
No.
Okay.
Okay. So You know, as I said when we started, it's what are you leasing?
Mm-hmm.
You know, what are the premises that you're leasing? There's no law or regulation that says that, you know, if you sign a lease for 2,000 square feet, that you're also responsible for the sidewalk in front of your store. That has to be specified. You know, are you responsible if you have a store in a shopping center for shoveling the walk in front of your store when it snows? Presumably, that has to be determined in the lease. There's no law that I'm aware of, one way or the other, that governs that. Similarly, having a cap on your CAM expenses, there's no law that governs that. So a lot of these things are just a matter of negotiation and understanding the implication of various things in there. And, you know, if you're the tenant, I would say, you know, read the lease. Some leases are a lot easier to read than others. We have a client right now who I won't identify, who had an attorney. They've now changed attorneys. But the attorney wrote a nearly impenetrable lease. I mean, it's very, very difficult to read, very long, very intimidating, particularly for the kind of tenants that are in their space. But it's incumbent upon them and to get an advisor who can read it and say, yeah, you can live with this. No, you can't live with this. You know, you should try and negotiate this away. Or I can tell you that when my son was leasing an apartment in New York City, I said, send me the lease, I'll look at it, I will tell you whether you can sign it or not. I said, it's New York City, you know, apartments are in demand, you're not going to get them to change it, so I'll just tell you, yes, you can sign it, no, you can't.
Yep. Well, thank you for clarifying. And speaking about the avoidance of falling into these the lease pitfalls, what is the worst situation or difficult or challenging situation you've ever seen a tenant in due to the lease?
That's a tough one to come up with a worst. I can come up with some examples, and you asked me this question before and I was thinking about it. One of the examples is us. We signed a lease for our office, and the lease had in it that we're responsible for our pro rata share of the operating expenses for the building above the base year, which means that we're responsible for our share of whatever the expenses increased by.
Wow.
So we were here for 5 years, and there have been significant increase in expenses, and we're negotiating a extension of our lease. So I was clever enough to say, look, I want to reset the base year.
Okay.
So we reset the base year, which was very clever of me. We happened to reset it to 2020, which was essentially the year that we renewed. Well, in case people don't know, there was a pandemic in 2020, and the building was basically shut down for the year. The operating expenses were very low. So then, when we got our bill for 2021, which the operating expenses increased over 2020, there was a substantial increase over 2020 because 2020 was very low. So, you know, and I looked at it and said I was too smart by half for my own good. If we had set the base year for 2019, we would have been in a lot better shape. I've seen situations where it actually works the other way, where a tenant negotiated that their operating expenses won't increase by more than 5% over the previous year. And 1 year, the landlord for whom we manage got a great deal from a landscaping and snow removal company that was just starting out. So costs went down dramatically that year. 2 years later, that company was out of business and costs went back up, but that tenant benefited from the fact that the costs had dipped 1 year and now they're restricted to 5% per year forever.
Wow.
So these are the kinds of things, there's no law one way or the other. It's just having experience, being able to read the text and having enough experience to know what it means.
Yeah.
And these things are, in several places in the lease.
Mm-hmm.
I'll give you a big example, and this is, I have to say, we managed for the landlord, and I thought this was unconscionable, but I did save a subsequent tenant in a different place money on this very issue, which was, it's common in shopping centers for tenants to pay their pro rata share of the costs of maintaining the common area, the insurance, and the real estate taxes. And the way leases for this one landlord were written was that the tenants would pay their pro rata share of the leased square footage. Okay. And I'm not sure that any real estate attorney is going to pick up the significant difference between, in this long paragraph, between leased square footage and leasable square footage. But just to give you an example, if you have a Food Lion center with a 35,000 square foot Food Lion and 15,000 square feet of small stores, you have 50,000 feet. If you have a 5,000 square foot store in that shopping center, you're paying 10% of the costs of plowing the snow, sweeping the center, etc. If Food Lion were to suddenly leave, they come to the end of their lease, or Food Lion has a strategic bankruptcy and says, we don't want this store anymore, they leave. Now all of a sudden, you have 5,000 out of 15,000 square feet. If you're on leased square feet, not leasable square feet. Now you're paying a third of the cost of plowing the parking lot instead of 10%. That's a significant difference, and it's one word. It's one word in a lease. And I was asked I actually volunteered to review a lease for a liquor store friend of mine, and I picked that up in it and said, you can't live with this.
Yeah.
This is not only something you can't live with, it's not fair.
Yeah. Wow. I mean, I cannot imagine the challenge and everything you went through during that time. I feel that just like I mentioned about these common pitfalls and tenants trying to avoid, these issues, everything goes hand in hand. So what exactly could happen if a tenant needs to break the lease early for whatever reason? Are they required to pay the remaining amount of their term? And does that even, kind of conflict with the agent's commission? How does that all work out?
That's a lot of questions.
We can break it into different pieces.
And if I haven't done it before in this conversation, let me say I'm not an attorney. I don't play one on TV, and I did not stay at a Holiday Inn Express last night, so I am not qualified to provide legal advice. The short answer is, if you've signed up for a certain term, you're obligated for that term. Then it comes down to, how did you sign the lease? Did you sign the lease in a corporate name, or the name of an LLC, or did you sign it in your personal name? If you signed it in your personal name, did you sign it, together with your spouse? If you signed it in a corporate name, did you guarantee it? And then there's the question of, how much have you been talking to your landlord? Have you been honest about the difficult times you're having? Why are you leaving? There's a million reasons. Is your landlord a jerk? That's an important question. Is it worth their going after you? We have a tenant that I just met with on Sunday. We're just letting her leave. Okay. She owes us probably, she owes my client like $14,000.
Wow.
But it would probably cost us $6,000 just to go after her and get a judgment, and there might not be anything there. And is it really important that we ruin her life, any more than it already is, because she had to walk away from a business? So it's what they call a facts and circumstances thing. It's a question that's impossible to ask. Legally, yes. If you signed a 3-year lease without the opportunity to cancel it early, then the entity that signs the lease owes the remaining term.
Yeah.
That's the fundamental answer.
Yeah.
And how does it affect the commission? in theory, the real estate agent is not the guarantor of the lease. We try and get paid up front, but there are times where you might say to the client, look, okay, you paid me for a 3-year lease, the guy left after 1.5 years, I'll credit you 1.5 years worth of commission against the next deal. Yeah. So, but it's it's facts and circumstances, how many jerks are involved in the deal, etc.
Which type of leases are generally the best for tenants, in your opinion?
Well, the best for tenants is probably the worst for landlords. Leases run in terms of, I did a blog article on this, on shifting the risk. So on the one end, you have what's called an absolute gross lease. An absolute, in that situation, the tenant is paying the rent, the agreed upon rent, and every other cost is the landlord's responsibility. Okay. In an absolute net lease, which is typical if somebody's leasing a freestanding building, or even building a freestanding building on a leased piece of ground, then the tenant's responsible for all the costs, all the extra costs, the maintenance, the insurance, the taxes. So, best for the tenant is for the landlord to be responsible for everything, and best for the I won't say worse for the tenant, because you go into it with your eyes open. You have an idea what the taxes are going to be. You have an idea what the insurance is going to be. You hopefully have an idea what the common area maintenance is going to be. And you may be able to negotiate a better deal if you're willing to take more of the risk. If, let's say you're looking at a $20 a square foot rent plus CAM taxes and insurance, and you expect those CAM taxes and insurance to equal $5 a foot, so you expect to pay $25 a foot total. Well, if you try and shift that to the landlord and say, I'll give you $25 a foot, but you're responsible for all the costs, the landlord may say, I really want $27 a foot because you're asking me to take the risk. Whereas a tenant might get away with $20 a square foot plus $5 of extras if he's willing to take the risk. So there's no better or worse. Everything's a negotiation and evaluation. It's just, the important thing is not having hard and fast rules. The important thing is understanding the implications of what you're signing, what decisions you're making, etc.
So this kind of goes into, my next question that I have is, what if the landlord finds that the timeline the tenant is looking for is not in the criteria they're wanting, but the tenant is pushing because they like that space? And also, what if the agent provides what lease they think is best for them, but then again, the landlord does not really accept that type of lease? How does that work out? How does that play out?
Okay, so those are two different questions.
Correct.
Okay. One has to do with the timeline, and to some extent it is what it is. If you're the tenant and you need to be in the space by June 1st, and I've got a tenant in that space and I can't make it available until December 1st, and you're not flexible, then we can't make a deal. I mean, it's very, very simple. I can't put two tenants in the same spot. So that's easy. I mean, the question is, you sit down and you talk. You say, is there some way we can do this? Can you, if you absolutely have to have this space and I can't deliver it till December 1st, is there something you can do in the interim? Can you operate out of your house? Can you operate out of a temporary office space? Or whatever. I mean, there may be solutions. I mean, the solutions to most problems between two people or two parties is to talk about them. And see if you can find a solution. The other question was about, just give me a couple of words.
Just what if, the agent provides what lease they think is best for the tenant?
Usually you start with the bigger dog in the fight. Okay. So when we were developing a shopping center in Winchester, Virginia. When we were dealing with, at the time, Circuit City, Bed Bath & Beyond, they were a lot bigger than Trout, Siegel & Doyle at the time. So we started with their lease form, and you negotiate from there. When we were dealing with the local tenants who were taking 2,000 square feet, Trout, Siegel & Doyle was the bigger party, the bigger dog in the fight. So we started with our lease form, and you negotiate from there. But it's all a negotiation, and both parties have the power until a deal is made. I mean, the tenant can walk away. I mean, there's a lot that goes into it. You know, how in demand is the space? If you've had this space on the market for 3 years and you finally got somebody that's willing to take it, you're going to give more concessions than you will if you put the space on the market last week and you got 6 people fighting for it. So most leases, if the two parties are sophisticated, are going to end up being some sort of a hybrid. Okay. It's uncommon for somebody to sign the lease without negotiating changes to it. And if they do, my experience is if somebody just says, fine, I'll sign it, it's because they don't really care what's in it, because they don't necessarily intend to live by what it says anyway.
Gotcha.
So that's it. I'd rather have somebody, negotiate every sentence, because it means that it's important to them and they know that what they sign they're bound to.
Absolutely. Well, this is incredible information, Art. Very so much insight. Thank you very much, for taking the time to speak with me about, mistakes tenants make when signing a lease. I think, having a better understanding of mistakes tenants make when signing a lease is crucial for everyone, regardless if you're looking for a space or not. Because I feel, knowing this type of information is only going to benefit the person at the end of the day. So I really appreciate.
I do want to say, I'm not crazy about mistakes, traps, pitfalls. This is an area where most people aren't experienced.
Correct.
If you go in and your doctor advises you that you need surgery on your little toe, if you don't understand all the implications, it's not necessarily a mistake that you've made.
Correct.
It's not a trap. It's just you don't know.
You don't know.
You don't know. So, my advice would be get somebody that that you trust. We talked about this the other day. People do business with people that they know, and trust.
Absolutely.
And that's what you need. And hopefully somebody who knows what they're doing.
Yep.
Okay.
And that's everyone at TD&A.
Yeah. Okay. Well, thank you. Okay.
Well, thank you, Art. I appreciate it.